Welcome back to the Deep Dive. We're your shortcut to being genuinely well-informed. Today, we're tackling a really important Supreme Court decision, one that just came down, and honestly, it redraws the map for workplace discrimination claims. This isn't just, dry legal stuff. It's about how anyone can seek justice if they feel they've been treated unfairly at work. So, our mission here is to unpack this unanimous decision, Ames v. Ohio Department of Youth Services. We'll look at why a specific rule, one that's been around for a while, got tossed out, and crucially, what that means for Title VII. That's the big federal law against job discrimination and how it protects you. Our sources, straight from the horse's mouth. The official Supreme Court opinion and a really interesting concurring opinion that went with it. We're aiming to pull out the key takeaways, make this complex ruling clear, and hopefully give you a real aha moment about your rights. Okay, let's start with the person at the center of it all, Marlon Ames. What actually happened to her?
Right, so Marlon Ames, she'd been working for the Ohio Department of Youth Services for quite a while, since 2004, actually. But then in 2019, things shifted. She was up for a management promotion, but she didn't get it.
Okay.
Instead, it went to a lesbian woman, and Ames is a heterosexual woman.
Okay, so that was the first thing.
Yeah. And then pretty soon after that, she was actually demoted from her job as a program administrator.
Demoted. What?
And the person hired to fill her old role, a gay man.
I see. So she felt this was happening because of her sexual orientation.
Exactly. She believed she was being discriminated against because she's heterosexual, and so she filed a lawsuit under Title VII.
But it wasn't smooth sailing from there, right? Didn't her case hit a wall pretty early on?
It did. Both the initial court, the district court, and then the appeals court, the Sixth Circuit, they ruled against her.
How?
They granted something called summary judgment to the agency she worked for.
Which means, like, the case was decided by a judge without even going to a full trial.
Precisely. Her case was essentially stopped in its tracks. And the reason why really hinged on one specific legal rule the courts were using.
Okay, let's unpack that. What was this rule that shut things down for Marlon Ames so quickly?
Well, the lower courts were using a standard kind of test, a framework, for these types of cases, disparate treatment claims.
Disparate treatment meaning you think you were treated differently because of your race or sex or religion, something like that.
Exactly. And often you don't have like a smoking gun email saying we're discriminating.
Yeah.
You have circumstances, evidence that points towards discrimination.
Makes sense.
So there's this common framework called the McDonnell Douglas framework. It usually involves a few steps. The first step is the plaintiff, the person suing, has to make what's called a prima facie case.
Prima facie, Latin, right, means like at first sight?
Yeah, basically. You need to show enough initial evidence to suggest discrimination might have occurred, just enough to get your foot in the door, to let the case move forward.
Okay, so that's the usual first step, but something extra happened in Ames's case.
Right. This is where it gets unusual. The Sixth Circuit applied this additional rule, often called the background circumstances rule.
Background circumstances.
Yeah. And this rule said that if the plaintiff was part of a majority group, and they considered Ames as a heterosexual woman, part of a majority in this context, she had to do more.
More than the standard prima facie showing.
Yes. She had to show, and I'm quoting the rule here, background circumstances to support the suspicion that the defendant is that unusual employer who discriminates against the majority.
Wow. That sounds subjective, an unusual employer.
Very. And the court was explicit. She had to show this in addition to the normal prima facie elements.
So hang on. If you're considered part of a majority group, whatever that means in a given situation, you face a higher hurdle, a tougher standard just to start your case.
That's exactly what this rule did. It created a heightened evidentiary standard, but only for certain plaintiffs based on their group identity.
That does sound incredibly subjective. And you mentioned defining majority could be tricky.
Absolutely. That was a huge problem with the rule and something the Supreme Court picked up on. Its application was all over the place.
So what did the Supreme Court do about this rule?
Well, what's fascinating here is they were unanimous. Every single justice agreed. They completely rejected the background circumstances rule, threw it out.
Unanimous.
Yeah.
That's significant. Why? What was their reasoning?
It was very direct, actually. First, they looked straight at the text of Title VII itself.
The actual law passed by Congress.
Right. The part about disparate treatment, 42 U.S.C. Sections 2000 E2A, it clearly says the law bars discrimination against any individual because of things like race, sex, religion, etc.
Any individual. Seems clear.
Exactly. The court said the text draws no distinctions between majority group plaintiffs and minority group plaintiffs. They basically said Congress wrote any individual, and courts don't have the authority to add extra requirements just for majority individuals.
So the text itself didn't support this special rule.
Not at all. And second, they pointed to their own past decisions, their precedents, which consistently say Title VII protection is equal.
Ah, like other cases had already set this principle.
Yes. They cited Griggs v. Duke Power way back in '71, saying Title VII forbids discriminatory preference for any group, minority, or majority.
Okay.
And McDonnell v. Santa Fe Trail from '76, which specifically said Title VII protects white employees from racial discrimination using the same standards as it protects black employees.
Yeah, same standards for everyone.
Exactly. And even the more recent Bostock case from 2020, which dealt with sexual orientation and gender identity, reaffirmed that the law protects individuals of both sexes from discrimination and does so equally.
So precedent was strongly against treating different groups differently under Title VII.
Overwhelmingly so. And third, the court also noted that their precedents generally warn against applying these kinds of frameworks, like the prima facie test, too rigidly or inflexibly.
How did the background circumstances rule violate that?
Because it automatically imposed this extra burden on all plaintiffs deemed part of a majority group, regardless of the specifics of their case. It was exactly the kind of inflexible, across-the-board rule the court had warned against.
Okay, so the rule was inconsistent with the text, with precedent, and with the idea of applying these tests flexibly. Makes sense why it was rejected. So what does this actually mean for Marlene Ames now, and for others in her situation?
It means her case goes back. The Supreme Court vacated the lower court's decision, basically wiped it out and remanded it, sent it back down.
For them to look at it again.
Yes. Look at it again without applying the background circumstances rule. She and anyone else filing a Title VII claim now faces the same initial standard, regardless of whether they belong to a so-called majority or minority group.
That seems like a huge step towards fairness and consistency.
Definitely. It levels the playing field at that crucial first stage of a lawsuit.
But wait, you mentioned a concurring opinion. That suggests there was more to the story, even though the decision itself was unanimous.
That's right. And this is where it gets potentially even more significant for the future of employment law. Justice Thomas wrote a concurrence, joined by Justice Gorsuch.
And a concurrence means they agreed with the outcome, getting rid of the rule, but maybe for different or additional reasons.
Exactly. Thomas's opinion went much broader. He used this case as a jumping-off point to critique the whole idea of judges creating these complex legal frameworks and rules that aren't actually found in the text of the law itself. He called them atextual.
A textual meaning, not based on the words Congress wrote.
Precisely. He saw the background circumstances rule as a prime example of this problem. He pointed out it was just invented by some D.C. Circuit judges back in 1981.
Invented? Based on what?
Based on what they called common sense at the time, apparently. Not based on anything in Title VII's text.
Huh. Just common sense.
Yeah. And Thomas argued this led to all sorts of problems. The rule was vague and ill-defined, as he put it.
Like the whole who is the majority issue we talked about.
Exactly that. Is it based on the national population, the local workforce, a specific industry? He gave examples. Women are a majority nationally, but might be a minority in, say, construction. Racial majorities shift drastically city by city, state by state.
So the rule was practically impossible to apply consistently.
Right. And Thomas noted that in practice, courts often ended up applying it mostly just to white plaintiffs or male plaintiffs, even if they were actually in the minority in their specific workplace or region.
Which sounds like it could create the very kind of group-based preference Title VII is supposed to prevent.
That was exactly his point. He argued it created an explicitly race-based preference, in some cases, contrary to Title VII and maybe even the Constitution.
Wow. Okay, so he strongly critiqued that judge-made rule, but did he stop there?
No, and this is the really provocative part. He then turned his attention to the McDonnell Douglas framework itself, the standard three-step process we discussed earlier.
The one that's been used for decades.
For over 50 years, yes. He questioned whether that framework is really appropriate, especially when a court is deciding summary judgment, that early stage where a judge decides if there's enough evidence to even go to trial.
Why? What's the issue with using McDonnell Douglas there?
Well, again, he argues it's atextual. You don't find McDonnell Douglas written in Title VII. And he raised several specific problems.
Okay, wait.
First, he said the language used in the framework, talking about proving a case by a preponderance of the evidence, doesn't really match the standard for summary judgment.
Which is just about showing a genuine dispute of material fact, like just showing there's something real to argue about.
Exactly. Summary judgment isn't supposed to be a mini trial where you fully prove your case. He thinks McDonnell Douglas asks too much, too early.
Okay, what else?
Second, he argued it's incomplete. It doesn't really account for all the ways someone might prove discrimination under Title VII. For instance, there's a provision for mixed motive cases.
Mixed motive.
Where discrimination was a motivating factor, even if there were other legitimate reasons too. McDonnell Douglas is more focused on proving the employer's stated reason was a pretext, a lie. The mixed motive path is different.
I see. So the framework doesn't cover all types of Title VII claims.
That's the argument. Third, he criticized its focus on distinguishing between direct evidence and circumstantial evidence.
Is that distinction important elsewhere in law?
Not usually, no. In most civil cases, circumstantial evidence is just as valid as direct evidence. Juries weigh both. He thinks the framework creates an artificial and unnecessary divide here.
Interesting.
And finally, he basically just said the whole framework has befuddled courts and lawyers for half a century. It's caused continuing confusion.
So after critiquing both the background circumstances rule and the main McDonnell Douglas framework, what did Justice Thomas suggest instead?
His suggestion was surprisingly simple. He said, why not just use the regular rule for summary judgment? Federal Rule of Civil Procedure 56.
The same rule used in almost all other types of civil lawsuits.
Exactly. Just apply the standard text of Rule 56. Is there a genuine dispute of material fact? If yes, the case goes forward. If no, it doesn't. No need for these extra judge-made layers specific to Title VII.
That would certainly simplify things.
That seems to be his view. Get back to the text of the rules in the statute.
Okay, this has been a lot to unpack. Let's bring it back home. Why should you, listening right now, care about this deep dive into legal frameworks and concurring opinions? Well, first, and this is the direct result of the main ruling, it affirms Title VII protects everyone equally. No matter if you're considered part of a majority or minority group, the starting line for proving discrimination is the same.
Right. That higher bar, that extra hoop for certain people to jump through, it's gone. Level playing field.
And second, that concurring opinion really pushes us to think critically, doesn't it, about how laws get interpreted.
It really does. It's a stark reminder that even legal rules that have been around for ages, rules judges created with perhaps good intentions, can sometimes drift away from the actual laws passed by Congress.
And potentially create confusion or unfairness along the way.
Yeah. It highlights this ongoing tension, this debate, about how closely courts should stick to the literal text versus creating framework to help apply the law.
It makes you question things you might have taken for granted about how the legal system works.
Absolutely. It underscores that focus on the statutory text, which is a major theme in legal interpretation debates right now.
Okay, so let's recap the core takeaway. The big one is that the background circumstances rule is officially dead. Title VII claims should now be more uniform, same standard for everyone at the start.
Correct. Big win for consistency.
And the other big piece is this bubbling conversation, highlighted by the concurrence, about whether other judge-made rules, even foundational ones like McDonnell Douglas, might need a fresh look.
A potential simplification, or at least a reevaluation, could be on the horizon based on sticking closer to the text.
So here's something to think about. If a long-standing judge-created rule like background circumstances can be struck down because it wasn't in the original law and caused confusion, what other established legal doctrines, maybe even outside employment law, might face similar challenges in the future? Could we see a trend towards simplifying legal tests by going back to the original text? And for you personally, how might this shift towards textualism and equal standards potentially make navigating an employment discrimination claim, if you ever face one, more straightforward and, well, more fair? Lots to consider there. That's all for this deep dive. Thanks for joining.